Welcome to Canadian Justice. I'm Christine Van Gyn, and today we're talking about the right to disconnect, a proposed employment right regarding the ability of people to disconnect from work, like emails or text messages, during non-work hours. Digital tools and the increase of work from home has blurred the boundary between work life and home life for many employees. While for some employees, work from home and the use of email, texting, and home computers brings freedom and flexibility, for others, the blurring of boundaries can cause undue interference in their private lives. In late 2021, Ontario passed the Working for Workers Act, which includes requirements for certain employers to establish a right to disconnect policy and the banning of businesses using non-compete agreements. Here today to discuss the concept of the right to disconnect and Ontario's new law are two employment law experts. Mackenzie Irwin is an employment lawyer with Samfiru Tamarkin, and Andrew Shaw is an employment lawyer with Baker McKenzie. Thank you both so much for joining me today. Mackenzie, I want to start with you. Let's get to the basics. What is entailed in this notional right to disconnect? What does that right involve?
Yeah, so the new legislation actually defines the term disconnecting from work, and it defines it in the Employment Standards Act as not engaging in work-related communications, including emails, telephone calls, video calls, or sending and receiving or reviewing other messages so as to be free from the performance of work. It's a mouthful, but the purpose of the legislation really is not really to give employees a specific right to disconnect, but it's more to really get employers to turn their mind to this issue that we're now facing, where we're blurring the lines between work and personal time.
Andrew, sort of same question to you. What's this notional right to disconnect all about?
Yeah, I mean, I think that's right. What Mackenzie said, Bill 27, it just requires employers to create a policy that outlines what has really already been law, that when employees aren't on the clock and getting paid, they shouldn't be working. The right to disconnect isn't itself a new right. It was already prescribed under the Employment Standards Act in relation to things like hours of work, payment of wages, overtime, and it doesn't create a statutory right to disconnect. Rather, it just requires employers with over 25 employees to have that written policy, which outlines what's expected in terms of work-related communications like emails, and not sending or reviewing any messages when they're off the clock. Now, some employees, I think, are going to think this legislation imposes on employers a right to disengage, and that's not the case.
So, Andrew, I want to get into the specific details of this law in the next segment, but the legislation also creates a limit on what are called non-compete clauses. Can you explain to our viewers what a non-compete clause is?
Sure, yeah. Actually, Bill 27 has a number of different facets, but certainly the right to disconnect and the non-compete clause, probably the most important. A non-compete clause, it prevents employees from getting a job with a competitor of a former employer or start their own competitive business. It's a way for employers to protect their business from employees who learn, the tricks of the trade, then leave, and then use that knowledge to undermine their former employer's competitive advantage. So Bill 27 includes this prohibition of non-compete clauses in Ontario for non-executives outside the context of a sale of business. I would note that Ontario courts were already very hesitant to enforce non-compete agreements before. So this really is kind of perhaps just a codification of that.
Mackenzie, what can you add to this discussion on non-compete clauses? For example, how might the prohibition on these clauses benefit employees?
Yeah, so as my friend said, it's essentially codifying what the courts have already been saying all along. When these non-competes come across my desk, I 9 times out of 10, they're not worth the paper that they're written on, and because they're unenforceable. So it's essentially codifying what we already know. But it is really important for employees because it's now basically it will hopefully deter these unnecessary litigation surrounding trying to enforce those for non-executives and for outside the context of the sale of a business. But that's not to say that if you're an executive or you're within the context of a sale of a business, that you're automatically, and the non-compete is automatically enforceable. It's now saying that, those are still permissive, but employers will still need to prove to a court that they're reasonable and necessary and as minimally invasive as possible.
We got to go to commercial, but we'll be right back. Welcome back to Canadian Justice, where we're discussing the right to disconnect in employment law. Now, Mackenzie, what can you tell me about this legislation in Ontario that creates this obligation on workplaces to create a policy on the right to disconnect? What workplaces are covered, and what are employers expected to do in order to comply?
Yeah, so the legislation requires that all employers in Ontario with 25 or more employees to have a written policy establishing their employees' right to disconnect and to provide that policy to all of their employees. So obviously it covers workplaces with more than 25 employees. That includes those that also work from home. So it's not just employees who work in an office. And in order to comply, the employer must have, it's really quite simple. The employer has to have their policy in writing by no later than June 2nd of 2022. They must provide the policy to their employees, and they must ensure that the policy is dated, and any updates that they make to the policy must also be dated. So other than that, the legislation doesn't really require the policy to include any specific information, and employers are really free to determine the specific contents of their policy themselves.
So, Andrew, what might a policy look like when it's being developed? What kinds of things might be included by the employer?
Sure. What would be included likely would be something like, the employer's expectations of employees to read or reply to work-related emails or answer work-related phone calls after their shift is over. Employer expectations for different situations really depends on, the time of day of the communication, the subject matter of the communication, such as if it is a staffing inquiry or actually work-related. I think that in particular is a big issue. If you're being asked to just say whether you're available, is that actually performing work? And also things like who ought to be contacting the employee, who's allowed to contact the employee. Could it be a client, supervisor, or even a colleague? In terms of the employer's requirement, other things that could include would be, for employees to turn on their out of office notification when they're not going to be responding. What's interesting is that the Employment Standards Act, to Mackenzie's point, there isn't a lot of guidance here, but it does state in the legislation that the policy shall contain such information as may be prescribed. So I know a lot of my colleagues think that we're still expecting for certain regulations to be published, which will prescribe additional requirements for what is needed in that policy. But as of right now, it's really just the need for the policy by June 2nd, 2022. So employers should start preparing these policies and thinking about the impact that it may have on their operations. And I would note also that, the timing is kind of impeccable. And in terms of implementation, it could get more difficult if one of the opposition parties wins the next provincial election, depending on how they want to implement it.
So, Andrew, to be clear, a policy would say employees don't need to respond outside of work hours, but is there a limit on contacting the employees? Like, so if the employer wants to send emails after hours, is that prohibited?
Yeah. I mean, what you suggest could be what's in the policy. Well, also it could be the opposite. It could be when we can contact you. So we may be able to contact you in an emergency situation, in which case there's actual work to be done. In that case, the individual would have to be paid, or we would contact you to see if you're available for a particular shift. I think the policy would probably say we will not contact you and require you to work off the clock without being paid, and without being provided with overtime in certain circumstances.
So, Mackenzie, if an employer violates their own policy and does have an expectation for employees to do work when it's outside of work hours, what would the consequences be of that violation?
Yeah, so the Ontario government has been quite lenient here in the sense that they've given employers, full reign on what they choose to include in their right to disconnect policies. So employers are going to have to be very cognizant of what they end up putting in there, because they're going to be held to those policies. So let's say, for example, that it says that we will not contact you outside of the hours of 9 to 5, and they do contact you outside of those hours. An employer cannot expect that employee to respond, because it would be in breach of their own policy. So the legislation is also opening up the door for an employee like that to seek enforcement of that policy under with the Ministry of Labor.
We've got to go to commercial, but we will be right back. Welcome back to Canadian Justice, where we're discussing the right to disconnect and employment law. Now, Andrew, how can employers adapt to this right to disconnect and the new legislation in Ontario when the nature of their business is highly demanding? For example, I don't think that this legislation would apply to law firms, but but maybe I'm wrong. How can employers adapt when they need employees available outside of the 9 to 5?
Yeah, I mean, Bill 27, the right to disconnect, it doesn't actually change requirements regarding when and for how long employees can work, when overtime kicks in, those sorts of things. That's already in the legislation. So employers can still schedule employees to work outside of the regular 9 to 5. They just need to have a policy which states that employees shouldn't be answering work emails, calls, and those sorts of things when they're off the clock. So I think that's the key thing is, are they off the clock? Will they be paid for this work that they're being asked to do? Even before Bill 27, overtime eligible employees shouldn't have been answering work emails, calls, et cetera. We know that often they do, but they shouldn't have been when they're off the clock. In cases where they are, they're technically entitled to be paid for that time. We've seen this happen a lot more during this remote work era. And I think Bill 27 is trying to address that by making employers draw boundaries and making employees aware of those boundaries.
And just to clarify my question, would this legislation would not apply to law firms, for example?
It would not apply to lawyers.
Right, okay.
Who would be exempted.
Okay.
Correct, yeah.
So, Mackenzie, how would this legislation apply to management? In a high performance environment, even if this legislation applies to you, I know a lot of high performing employees who will, of course, continue to answer emails outside of the 9 to 5. And doesn't this legislation, while well intended, does it create a pressure to just work and then not report those hours?
So I want to be clear, this legislation does not prohibit people from working outside of their normal work hours. So if an employee chooses to go above and beyond, that's not in violation of this new right to disconnect legislation. In terms of management or executives, the Ontario government has been clear that this legislation applies to everybody in your organization. So employers are going to have a policy that can apply to all of their employees, or they might have different policies that apply to different people in different positions. So employers are really going to need to take a step back and assess what their needs are and determine how many policies they're going to need and how many policies they're going to have applying to different positions.
Andrew, same question if you want to add anything there.
I think it's for more senior employees. I think that it does create, there's a different kind of dynamic for sure, and maybe that multiple policies might deal with it, but there's definitely going to be more difficulty in applying this in certain professions at certain levels.
Mackenzie, I was wondering if you could paint a picture for our viewers about why employees might feel that this type of legislation is necessary. What are some examples of where having a policy in place about right to disconnect might be especially helpful for employees. I mean, what might you be hearing from your clients?
Yeah, absolutely. So I'm a firm proponent of the fact that employers really need to clearly and properly communicate their expectations of their employees. So this legislation is timely and necessary because it forces those employers to do just that. Particularly during a time when a large percentage of the workforce is now working from home, and the expectations have really changed from the times when they were working in the office. So for employees, come June 2nd, 2022, it's going to be really great for those employees to have a written policy that they can look to, and that should clearly outline what's expected of them in terms of their right to disconnect. And if an employee feels that their employer is not abiding by that policy, they will now have something to point to establish that breach. This legislation also opens up the door for an employee to seek assistance from the Ministry of Labor in enforcing their right to disconnect policy. So I think we will see a lot more employees coming forward with specific breaches of their right to disconnect policies.
We've got to go to commercial break, but when we come back, I want to look at some other areas of the world or other jurisdictions where there is also right to disconnect legislation and what we can learn from those jurisdictions. We'll be right back. Welcome back to Canadian Justice, where we're discussing the right to disconnect and employment law. Now, Andrew, this type of legislation is new to Ontario, but it's been used in other places, other countries, and other jurisdictions. What can we learn from other places the right to disconnect legislation exists?
That's right, Christine. Laws like this really aren't new. We've seen similar laws in France, Spain, the UK, and Belgium applied to varying degrees. And I'm sure there's others. I'm not specifically qualified to talk about the implementation of that legislation in those countries, but the extent to which they are effective from what I've read is arguable. I think in remote work arrangements, and particularly for employees who perform client services and so-called knowledge workers, the lines between work and personal life can get pretty blurred. For these kinds of employees, the way they produce work isn't linear. They'll perform personal tasks during the day or during what's considered the normal work day, and then work during what's considered personal time. And it's not the kind of work where you can easily turn it off and say, okay, I'm not going to think about this task or answer any client calls after 5 p.m. and I'll start thinking about it again at 9 a.m. tomorrow. It just doesn't work like that. So I guess, what I'm saying is that it's not clear how much of an impact this legislation will have for most employees and how much it has in these other jurisdictions. The kinds of employees that perform manual tasks probably already don't answer work emails and calls when they're off the clock. And the kinds of employees who do are, for the most part, or could be exempt from hours of work and overtime provisions. So they're always on the clock. But as Mackenzie says, it technically does apply to everybody. So hopefully it should have some impact.
Now, Mackenzie, you and Andrew have both pointed out that this is just a requirement to create a policy by employers. And to me, this seems a bit more like an attempt to create a cultural shift. How much of that do you think is true versus this being something that's really enforceable? Is this about really a change to the law, or is this a change to culture? And which one is more important?
Honestly, I think it's both. I think it's a really important step that the Ontario government is taking towards, spurring that cultural shift. So it's clear, the Ontario government doesn't know each employer's specific needs. And I think that's one of the main reasons why they haven't mandated certain things to be in these policies. They've given employers the ability to choose what they will put in it. But it's really no surprise that employers who prioritize a healthy work-life balance tend to have a happier workforce with less burnout and a higher talent retention. So I think in terms of whether or not the legislation really forces us into that direction, I think the cultural shift is kind of already brewing, and I'm hoping that this legislation will be an important first step towards that.
Andrew, same question to you. Do you think this is more about a legislative shift or a cultural shift, and which one would make a bigger difference?
Yeah, I think there's 2 points to say here. I think, this legislation clearly stems from what employees have experienced during the pandemic. I've read that work days are just getting longer and longer as you work from home 10, 11 hours. So I think it kind of was created out of that. There's obviously a political angle to this, an election coming up, the desire for the current government to appeal to a certain segment of the actually, a lot of the population. That's part of it as well. But does it kind of follow up on a current cultural shift that started during the pandemic? I think it did.
Andrew, last question. We've got about 30 seconds, but we've been talking about Ontario. Do you think that this type of legislation, we can expect it to see in other jurisdictions in Canada?
There's always the possibility that it'll spread to other provinces, for sure. I know that the federal government is considering implementing similar legislation, so the Canada Labour Code could be amended to include similar legislation. So watch out for that.
Well, Mackenzie Irwin, Andrew Shaw, I want to thank you both for coming on today and sharing your expertise and your time about employment law. It was a really fascinating discussion for me.
Thanks so much for having us.
Yeah, thank you very much.
We've heard today about the right to disconnect from work, where these laws exist and how they work, and how it will apply once enforced in Ontario. Striking the right balance between work and home life is hard. Speaking for myself personally, there is no distinction between work and home. Everything blurs together. But for me, I love my work and I find it incredibly fulfilling. But for others, I understand how the sanctity of home life must be preserved. How do we strike the right balance? You be the judge. Thanks for watching, and remember, a freer Canada starts with you.